what is social media? What do these platforms do? Should they have a role with disinformation? And does disinformation have a role in democratic discourse? And if so, what kind of role? I think those are the things that we want to talk about today. Let me just kind of take a step back and think about free speech at 30,000 feet and kind of the purposes why we have free speech in a democracy, and why it's so important to us in American democracy. So maybe first and foremost, one of the reasons that we have free speech is that we convey information with free speech, right? So for example, Barb sent me today the address of where I'm supposed to show up, and that's speech. It tells me where I'm supposed to be at what time, and I can follow that and get here, more or less on time, and basically follow her directions more or less correctly. So one purpose of free speech is just conveying information and communicating on a sort of day-to-day level. If we take it kind of a step up, we can think about free speech as development and education and flourishing and self-fulfillment and self-actualization and helping each other learn and develop in a democracy and share ideas so that we're developing and flourishing ourselves and helping each other to develop and flourish. And if we take it a step up in a democracy, we might think about free speech as democratic participation. That free speech allows us to participate as small d Democrats in a democracy, right? That we can disagree and discuss and argue about different issues, and that will help us develop policies that then will work in a democracy and reflect the general will. And related to that, we have this idea of marketplace of ideas. Marketplace of ideas says that in a free speech world, all speech is valuable. And through the marketplace of ideas, the kind of give and take between different speech, that the good ideas, the valuable ideas, the true ideas, that they'll kind of rise to the top. And the bad ideas, the false ideas, the misinformation, through more discussion, right? And this is key, through more discussion, those bad ideas or false ideas or misinformation, that those will kind of wash out. They'll wash out in this marketplace of ideas. Now, we can agree or disagree about the marketplace of ideas, and I think there's a lot to say about it. What's important for our discussion today is that's where the Supreme Court's head is. The more ideas, the better, in order to promote this kind of marketplace of ideas. The thing is, depending on our view of free speech in a democracy, we might consider different ways of regulating speech, right? And it's important to understand that free speech under the First Amendment is not absolute. We don't have an absolute right to free speech. The government can regulate our free speech. And if we think about speech as, democratic reinforcing, for example, one of the visions of speech that I spoke about a second ago, our view of permissible government regulation of speech might be very, very different than if we view speech as kind of a free-for-all marketplace of ideas. And so I want to start at that 30,000-foot level to kind of set the stage. What's so important about a discussion about misinformation is what place does speech play in a democratic society, right? What place ought it play in a democratic society? And do the answers to those questions help us sort out how we should deal with disinformation in a democratic society? And I hope that we can engage around some of those questions. Now, what I want to do is sort of give you a little bit of doctrinal background on where the Supreme Court is with free speech, just to set the stage for the couple of cases that Chris and I are going to talk about. I mentioned a second ago that free speech is not absolute, and that's really the starting point. That whatever else we think about free speech in our system, it's not an absolute right, that the government can regulate free speech in certain ways. And we know this through our lived experiences. We experience government regulation of speech in different ways all the time. Next point, free speech only applies against the government. This will become important in both of the cases, all three of the cases that Chris and I discussed today, but particularly in Chris's case, that free speech only applies against the government. There needs to be a so-called government actor behind the claim against a government intrusion on free speech. I don't have a free speech claim against you. You don't have a free speech claim against me, but we together have free speech claims against the government. Now, the sort of flip side of that is that the First Amendment doesn't restrict the government in government speech. The government can say whatever it wants. The government can say whatever it wants in terms of the content of the speech that it conveys, and also in terms of the viewpoint of the speech that it conveys. Again, that's an idea that'll become more important when you hear Chris's case today, but the First Amendment doesn't restrict the government in what the government has to say. Now, in terms of regulation of speech, we know that free speech is not absolute, but I can tell you that if the government seeks to regulate speech based on its content or based on its viewpoint, mostly those government regulations are going to be invalid. The idea here is that we don't like the government interfering with our content or viewpoint. We don't like the government telling us what we can say or what we cannot say with regard to content or viewpoint. And so the Supreme Court applies a very high level of scrutiny when it assesses government regulations that discriminate based on content or viewpoint of the speech. You can imagine, right? If the government were to tell us that we can talk about whatever we want to here today, but we can't talk about politics, right? A content area of speech. How ridiculous that would be. Of course, we'd want to subject that to heightened scrutiny. Or the government might say, you can talk about politics, but you can't talk about, you can't criticize the Biden administration, right? A kind of viewpoint on politics. Crazy. And we would expect the courts to apply a kind of heightened scrutiny against that kind of government regulation. Now, there are some exceptions to that. And if you think about them, some of these have been in the news, right? And so the government can regulate incitement, for example, or true threats, or fighting words, or obscenity, whatever that is these days. Or the obscenity doctrine is so crazy. Trying to teach this is just such a hassle these days with all the material that's out there. Who knows what obscenity is? Anyway, so the government can regulate obscenity. The government can also regulate commercial speech to some degree, and it can regulate things like libel or slander and defamation, right? So we know the government can regulate some content areas of speech, but we don't quite know how much. What the government can't regulate, and this is kind of interesting, this will come up in our discussion today, the government can't regulate lies unless lies produce some sort of legally cognizable harm. There's a case a couple of terms ago called Alvarez, where the Supreme Court ruled on a congressional statute that criminalized representing that a person received a particular government honor when they didn't receive it. And so this guy Alvarez was going around saying that he had received the Congressional Medal of Honor when in fact he had not. Now, his representation didn't produce any legally cognizable harm to anybody that was tangible to a particular person. Here we're thinking about harm in a kind of narrow sense. I'd obviously created a kind of harm for everybody, but the court said the government can't punish that kind of speech without a tangible, cognizable harm behind the lie. Lies are protected free speech. So when we talk about misinformation today, we want to think about lies as a form of protected speech unless they're producing a kind of tangible harm. And what's interesting about that is it's all about the marketplace of ideas, right? That lies are valuable in the marketplace of ideas. What we expect is that truth will shout them down and that those lies then will fall out of the discourse. We can use our own judgment about how well that works. I'll propose maybe not so well. And then final point before I want to talk about the cases that I'll talk about today is that government can't compel speech. And again, we'll hear more about this from Chris, but government can't tell you what to say. So while government can't regulate speech based on content or viewpoint, it also can't force you to speak in particular ways. And we've seen the Supreme Court rule on this in recent terms in interesting ways. Some of you may remember, for example, the 303 creative case that came down recently, and what the court saw as government compelled speech in that case. So with all that as background, let me move and talk very briefly about the couple of cases, one from Florida, one from Texas, that seek to restrict the way social media platforms can regulate content that they're releasing. And let me just give you a little bit of background. If you're like me, you may not be as familiar with social media platforms as, for example, my kids are, who live on the things. But social media platforms like Facebook, for example, or Instagram or YouTube, these are platforms that are out there on the web that host third-party content, right? And in hosting third-party content, they also make editorial decisions about what content to host, how to present that content, how to sequence that content or prioritize it, and ultimately what content to take down if that content doesn't comport with their own editorial guidelines. So what I'm telling you is that these social media platforms are not just sort of passive platforms for third-party speech, that they actually are engaged in some editorial choices, and they always have been, in terms of how to present the third-party speech, right? And we know this, again, from our lived experience. If you've been on Facebook recently, you know that the content is moderated in different ways. Well, in the COVID-19 era and through the 2020 insurrection, we saw a lot of false and misleading information come up on social media platforms. Social media platforms responded by regulating that speech internally, right? And saying, well, some of that speech we're going to deprioritize, some of that speech we might even take off of the platform entirely, right? This disinformation that actually is harming the public because it's telling the public misinformation about, for example, how to protect themselves against COVID, or disinformation about the fraudulent nature of the 2020 election. And so we see some content moderation. Now, before I go on, I just want to, call out the elephant in the room. This is all about politics, and I think everybody understands that. It's impossible to understand these cases without thinking about their political implications. The false or misleading speech that I'm talking to you about is mostly politically conservative speech, or at least what political conservatives see as politically conservative speech. Now, when social media platforms start shutting down politically conservative speech, politically conservative states get very upset about that, right? And so states like Texas and Florida then will step in and try to stop the social media platforms from regulating their speech on their platforms in a way that shuts down politically conservative speech. And as I'm saying that, I hope you're thinking about the place of social media platforms in our democracy, considering the different purposes that we have for free speech in our democracy, and considering the different doctrines that I talked about earlier, right? So far as we know, social media platforms are simply private platforms for speech. They can promote whatever speech they want. They're not government actors. They're not restricted by the First Amendment so far, but should they be, right? What place do they play in our democracy? Should there be a role for the First Amendment in social media regulation of their own internal speech? So anyway, Florida and Texas come back and they say, we're going to regulate social media platforms and their content moderation practices in a couple of different ways. And the laws here are a little bit different, and I'll just describe their differences very briefly. So in Florida, for example, Florida SB 7012, if you're taking notes and want to Google that, SB 7012 says that social media platforms can't moderate their content and censor their content based on the content of the speech, okay? And you might remember earlier I said the government can't regulate by content. I gave you the example of political speech as content area of speech. What Florida's telling the social media platforms is they can't regulate or restrict speech by content. And moreover, what they said is they can't willfully deplatform a political candidate. They can't take a political candidate off their platform for example, repeated misinformation. Not that we have any experience with that kind of thing in the United States, but that they can't take a particular candidate down for that kind of information. The Florida statute then goes on to say that when a social media platform does either of those things, it has to report to the third-party content provider what it has done and provide an explanation for what it has done, right? So Facebook takes down a post that they think is disinformation, they have to actually provide an explanation to the content provider that they've done that and why they've done that. And if you think back to what I talked about a second ago, you might be thinking, well, that kind of sounds a little bit like government compelled speech. Yeah, it does, right? Texas operates a little bit differently around the edges. What the Texas law says, and this is HB 20, if you want to Google that. What HB 20 says is that social media platforms can't regulate speech, they can't moderate their content based on the viewpoint of the speech, the viewpoint. Now, that difference between viewpoint and content probably doesn't make a big difference, if any difference, in this context. But just to be technically correct, they do regulate speech a little bit differently. The Texas law, like the Florida law, says that when a social media corporation does this, that the social media corporation has to provide notice and an explanation to users. So again, a kind of compelled speech of a sort, and we'll talk about that in a second, that the social media companies have to provide to third-party content providers. Now, all of this, and nobody is really even hiding the ball on this, all of this is designed to prevent social media companies from clamping down on disinformation about COVID-19 and disinformation about the 2020 election and the fraudulent nature or nature in general of elections going forward. Again, Florida and Texas, and most commentators see this as, in today's terms, politically conservative speech. There's other evidence that they're targeting social networks that might be targeting politically conservative speech, and that's that both of these laws only apply to really, really big social platforms. They only apply to the Facebooks, to the Instagrams. They don't apply to the Truth Socials because of the size of the platform. So there's a size restriction. What does all this mean? Well, the cases together, they really put front and center the question that I posed earlier, and that was, what role do social media companies play in our democracy? On the one hand, what the states are arguing is that social media companies are like what we call common carriers in our democracy. All they are is platforms for third-party speech. They're not engaged in any speech themselves. They're something like a telephone or a telegraph or a FedEx delivery truck that might be delivering your book that you ordered from Amazon, right? That what they're doing is delivering speech without making any editorial choices about that speech. There's no speech involved themselves. And as common carriers, then any regulation of them is not a regulation of speech. Instead, it's a regulation of their conduct. Their conduct that they have to accept all speech on their platform, you see. Just as you couldn't tell the FedEx delivery truck that they can only deliver politically progressive books that you ordered from Amazon, but not politically conservative books that you ordered from Amazon. So too, you can't tell, social media corporations can't tell political progressives that they can speak, but political conservatives that they can't. They've got to take all comers, just like any common carrier. And there's some Supreme Court jurisprudence that they point to in support of that. On the other side, there's an argument, and this is the argument of the social media platforms, that they actually engage in speech themselves, that they are engaged in speech by making these editorial choices that we talked about earlier. And so they're not a passive platform for third-party speech. Instead, they're actively engaged in promoting their own speech by making editorial choices about what speech they're posting, how they're prioritizing it, and how they're displaying it on their platforms. And again, there's Supreme Court precedent that, if you're interested, we can talk about in Q&A, that supports that position. So at the core of these cases, as I see them anyway, there's a question about what are social media platforms in today's society, in today's internet, in today's democracy, that really are important questions about how we engage in democratic discourse. The other question here in the cases, it deals with the compelled explanation that social media platforms have to provide when they control content by a particular user. There's some question about whether that's government compelled speech, but in the context of commercial compelled speech, the test turns out to be a little bit lower. And some commentators think that the states of Florida and Texas, that they can actually require social media platforms to provide this kind of explanation of deplatforming or deprioritizing certain speech, that they can actually do this under a kind of lower level test, which is a kind of interesting aspect to the case. And so I think with that, I'm just going to stop blabbing on and turn this over to my good friend Chris, and leave time for Q&A. Thank you very much.
Thank you so much, Steve. Can everyone hear me? Turn it. How's that? Yeah? All right. So thank you, Steve. Steve laid a lot of the groundwork on basic principles of free speech. So what I'm going to do is I'm just going to do a deep dive into an upcoming Supreme Court case. So I'm going to give a bit more detail on this case, touching on the bigger free speech themes that Steve alluded to, and then we'll have some time for discussion. Early in the Biden presidency, administration officials sought to counter the proliferation of what they saw as misleading and often erroneous information on social media platforms. They were particularly concerned about content, most prominently, as Steve alluded to, promoted by conservative voices, that criticized COVID vaccines, lockdowns, mask mandates, that challenged the results of the 2020 election, and it challenged the integrity of elections in general. An array of government officials engaged in a widespread effort to combat these conservative promoted claims. This effort did not include the use of government authority to directly regulate social media platforms. And this is why the case I'm looking at is going to be different than the cases that Steve just talked about, in which the governments of Texas and Florida were trying to regulate social media platforms. This is going to be something a bit different. In this case, federal government officials engaged in informal efforts to persuade, cajole, or strong-arm private platforms, social media platforms, Facebook, Instagram, YouTube, Twitter, to change their content moderation policies. The phrase for this is jawboning, the use of informal authority to try and get businesses to change practices. Now, how one characterizes these interactions between government and these platforms will be colored by one's views of the merits of the Biden's administration's agenda. And just to pick up what Steve said, it's all political, it's all ideological. To liberals, what the Biden administration was doing was defensible efforts of persuasion designed to fight the scourge of misinformation and disinformation. Democracy depends upon an open debate of issues, and misinformation, disinformation does not allow us to have open, free debates. Alternatively, to conservatives, this is government suppression of speech in its classic form. Conservatives also drew on principles of democracy and free speech. They argued that democracy depends on an open debate of issues, but this kind of suppression of speech does not allow open and free debates. Agree or disagree with the speech that the government sought to have suppressed, they argued, this is protected by the First Amendment. Now, as Steve alluded to, there are certain categories of speech that are pulled out from First Amendment protections, such as true threats, defamation. The speech at issue here was actually constitutionally protected speech. So this is speech that government could not directly regulate, but in this instance, they're trying to persuade, cajole, jawbone private businesses, these social media providers, to get rid of the speech, to clean up the speech, or at least deprioritize it. Lawsuits ensued, of course. The plaintiffs initially were 2 states, Missouri and Louisiana, and then we had added to this 5 individual users of social media who said that their speech was being limited by the providers because of the Biden administration's influence. The lawsuit was initially named Missouri versus Biden and is now going by the name of Murphy versus Missouri. The plaintiffs claim that the actions of various government agencies, including a great big long list of the entire Biden administration, basically. Surgeon General Vivek Murthy is now the lead respondent now. Also, Center for Disease Control, CDC, Cybersecurity and Infrastructure Security Agency, CISA, The FBI was involved, Justice Department, various White House officials. They're all thrown into this and named as defendants in the initial lawsuit. And the argument was that these people's actions resulted in censorship of conservative leading speech on a whole variety of topics. The plaintiffs argue that the defendants violated their First Amendment rights when they used their public statements and threats of regulatory action to induce social media platforms to suppress content. So let me just walk through what happened in the courts, because this is now before the big court, the Supreme Court. In July, in fact, July 4th, a U.S. District Court down in Louisiana issued a 155-page ruling that sided with the plaintiffs and granted the plaintiffs a motion for a sweeping nationwide injunction prohibiting federal government officials from meeting with social media companies or otherwise seeking to influence their content moderation policies. It just said Biden administration, stay away from social media providers. This was then appealed immediately up to the Fifth Circuit based on New Orleans, and the New Orleans court actually affirmed basically the lower court opinion, including the injunction, although they did limit the injunction. It's not quite as sweeping as it was at a district court level. And it had some very strong language, basically criticizing the Biden administration for, quote, engaging in a broad pressure campaign designed to coerce social media companies into suppressing speakers' viewpoints and content disfavored by the government. Keywords in there, content, viewpoint. You know, when the government is dealing in content and viewpoint discrimination, that triggers the highest First Amendment protections that Steve just talked about. This then was brought to the U.S. Supreme Court, and the U.S. Supreme Court did agree to hear the case. They did also pull this injunction. So that injunction that said that the Biden administration had to stay away from social media content providers is no longer in effect. It was stayed by the Supreme Court, although there were 3 justices on the Supreme Court who thought the injunction should have stayed in place. I'll name names. It's Alito, Thomas, and Gorsuch. Not super surprising. Again, there's a lot of politics involved here. So the injunction was lifted over these dissents, and the Supreme Court granted review, and they will be hearing oral arguments in this case on March 18th. I'll say parenthetically, if any of you have not listened in on these oral arguments, which are now live streamed and available through a variety of interfaces, it's fascinating, particularly if you can get a bit up to speed on what the case is about before you dive into oral arguments and you kind of know what the basics are. They're fascinating. You start to learn the justices' voices. And I'll also say, whenever the U.S. government's involved, and in this case, we have the U.S. government involved, we have one of the strongest advocates to come before Supreme Court in recent history in the Solicitor General, Elizabeth Proligar. She's just wonderful to hear her make arguments, and she will be arguing in this case for the U.S. government. All right, so that's the details of the case. Let me back up a little bit. I'm going to overlap a touch with what Steve just said, but I'll go through this relatively quickly. There are 3 big First Amendment principles that are hovering over this case. We need to make sure we have these straight. The first is that the First Amendment does limit the ability of government actors to directly regulate the speech of private groups and individuals. This is basic, right? Government can't tell us what to say, us being private individuals or private businesses. Government could not have used its authority to directly tell these social media operators to take down or limit the speech. We'll see what happens in Steve's case, but I think the best reading of existing law is this direct mandate, don't do this, to the social media providers would have been unconstitutional. Congress couldn't have passed a law doing what the Biden administration sought to do, right? So direct regulation would likely violate the First Amendment. But the First Amendment does not prevent government from expressing its own views and advancing its own agenda. This is called government speech, or, we talk about the president's bully pulpit. Yes, we want a government that can express itself. And there's First Amendment values there. We elect someone to represent the viewpoints that we embrace. And we want that someone, when they have office of authority, to express those viewpoints, to try and persuade and use that. So that is government speech. And government can advance viewpoints, can advance certain content, and that is not problematic from a First Amendment principle. All right, so that's principle number 2. First one, government can't directly tell you what to say, can't directly regulate speech, but government can speak on its own behalf. There is government speech that doesn't infringe the First Amendment. Now we get to principle number 3. The First Amendment does not limit the ability of non-government actors, private actors, such as private businesses that operate social media platforms, think Facebook, Meta, Twitter, all that, cannot directly limit their ability to regulate the speech of its users. And this is what's called the state action doctrine. Whenever I teach this, I say, private individuals cannot violate the First Amendment. So when I tell my kid to stop yelling at his sister and he says, "No, Dad, I have the First Amendment right. I can do what I want." Like a good con lost kid, right? And I'm so proud of him when he says this, but then I sit him down and say, "I'm going to give you a 30-minute lecture on the doctrine of state action, in which I cannot violate the First Amendment. Joe Biden can, I can't." Right? This is the idea here that private actors themselves can't violate First Amendment. And it is important, I'm just going to emphasize something that Steve said before, that what these social media operators, how they actually work. And again, the law could change so that they may have to work differently, but this is how they currently work. They are curated platforms. They're not open forums. They have terms of service or user agreements that establish community standards. You might not like them. It may feel like a free-for-all if you ever dip into some of these, but there actually are some requirements that one needs to sign on to when you join them. And people do use these, at least in part, because they want some level of regulation. They don't want pornography popping up on their Instagram every time they turn it on, or hateful messages in there. And this is because these social media operators do limit speech. They do regulate speech. That's part of what the business is all about. Therefore, private businesses can elevate, suppress, remove speech without running afoul of the First Amendment. And indeed, when government tries to tell private operators they can't do this, that itself raises First Amendment concerns. And those are the cases that Steve talked about. I will say here, it is important to recognize there's a difference between First Amendment principles, which are everywhere in our society, and First Amendment law, which is what you can actually win in court. So if you actually talk to people who work at Facebook, or you read what they put out about what they're trying to do, they actually embrace a lot of First Amendment principles, free speech principles. They say we want to have an open flow discussion, and their content moderation policies, they're actually quite careful with them because they don't want to infringe on speech. They do that because they value free speech and First Amendment principles. They don't do that necessarily because they would be running afoul of the First Amendment in court because they're private actors and they can't violate the First Amendment. So, again, when my kid says I have a First Amendment right, he's not all wrong, right? I mean, there is a sort of principle of we want to encourage expression in our society. But there's just a difference between these principles and the culture of speech and First Amendment and what actually happens in courts, and again, this gets a little bit confusing when people say, Facebook can't tell me what I can and can't say. Well, in a law, they can't, but maybe your claim that they should have some traction. Maybe Facebook should listen to you when you say these things. All right, so these three principles: government can't directly regulate speech, private actors aren't confined by the First Amendment, and government can speak on its own behalf. This applies then to this case, again, a case called Murphy versus Missouri. Now, if the federal government, if the Biden administration is just expressing its own views, acting in the capacity of government speech, and the social media platforms are maybe persuaded, government says you should take down this garbage, it's awful, it's misinformation, it's harmful, and Facebook says, yeah, this is pretty bad. They just agree with that. If it's just government speech and then the platform's being persuaded, then we don't seem to have a First Amendment issue. But if the government is going beyond persuasion, if it is in fact coercing, and whether this is persuasion or coercion is really going to be the key issue. If you listen to oral arguments, I have no doubt that is going to be the central factor of the discussion. If it's coercion, then yes, the First Amendment comes into play because government cannot coerce private actors and tell them what to say. Because if it's coercion, then the government moves from government speech to regulator, and that's a whole different game when you come to the First Amendment. So the U.S. government, in its briefs that they submitted to the court, argues that the Biden administration was engaged in government speech and not the repression of speech of others. In the brief, they wrote, quote, "So long as the government seeks to inform and persuade rather than to compel, its speech poses no First Amendment concern. And even if government officials state their views in strong terms, and even if private actors change their speech or conduct in response, it's still not a First Amendment violation." In contrast, the challengers, the people challenging the Biden administration's policy, they counter that the government crossed the boundary from persuasion to compulsion in dealing with these social media platforms. Their brief reads, quote, "The government can speak freely on any topic it chooses." They don't question the principle of government speech. "But it cannot pressure and coerce private companies to censor ordinary Americans, even if content moderation is put in effect by private actors," meaning that ultimately the policy was the policy of private actors. "If government officials were the ones pulling the strings," all right, that's coercion, "then government's responsible, then the First Amendment applies, and then what's going on here could raise First Amendment issues." The challengers also do emphasize the nature of some of the speech. And the problem is there's a ton of government speech involved in this case. Some of it is just administration officials saying, you know, there's a lot of misinformation out there about COVID vaccines, like just general things. And that misinformation shouldn't be up on social media, general. Some of it is much more specific. And some of the Biden administration rhetoric did include some things that the challengers are defining as threats, such as saying, if social media doesn't do a better job of cleaning up all this mis and disinformation, maybe we should revisit some laws out there that protect social media providers, social media platforms from certain forms of liability. And if you've ever heard of Section 230 of the Communications Decency Act, it's kind of an obscure statute that's become super important. Social media platforms are protected from a lot of liability for speech that comes through them, even in situations where it's some harmful speech, where someone could have a legal claim against the speaker. The platforms themselves are protected because of this federal statute. And sometimes some of the Biden administration officials said, maybe we should rethink this statute. And then the question is that a threat of government regulation trying to advance limitations on speech? So again, it's messy because there's just so much thrown into this case that some of it looks maybe kind of problematic and some of it looks pretty routine government speech in there. And the challengers are really, of course, putting their thumb on the scale of the more direct threat-oriented speech. All right, so the question the court will need to consider, were the Biden administration actions persuasion or were they coercion, intimidation, or threats? And I'm just gonna say, looking at this case, you know, I have my sympathies in terms of like whose positions I like better, but just on the merits of the legal claims, these are not necessarily easy questions, in part because there's just so much different speech involved. Outside of blatant and open coercion under the threat of criminal prosecution for noncompliance, like that clearly would, you know, threatening that we're gonna prosecute you, that would clearly be crossing the line. There are actually few bright lines. Coercion can often operate indirectly, and we should be concerned when government coerces people to speak a certain way through indirect methods. Threats can often be implied. The competing interests at play here do require very highly specific contextual totality of the circumstances, case-by-case analysis. And in this case, the platforms in the Biden administration seem to be working toward the same goals. Oftentimes you have the Biden administration just pointing out stuff to Facebook, and Facebook is like, thank you, yes, we will deal with this. Like they're pretty much on the same page, but you could also imagine scenarios in which the administration in office is not on the same page as some of these social media platforms. And then if you have some persuasion leading toward coercion, it would be more problematic. But I'll also say, looking at this case itself, the fact that the social media platforms and government were largely on the same page, working toward the same goal, like all sort of seeing certain forms of misinformation as problematic, that also could be a concern because now you have government in alliance with private actors, all pushing toward the same goal. And that too should be a concern from a First Amendment perspective. If government is actually able to get done what they couldn't do directly simply because they're in this close working alliance with private parties. So there's concerns on sort of all sides of this case. And we'll wait and see. Again, I encourage you to listen in on these arguments, follow what's going on, because this one raises some really deep, interesting questions. And it's always worth just thinking about if you flip some of the sides around, you put a different administration in office doing some of these same things, you really do think differently about these. And, you know, the court gets a lot of bad press for some legitimate reasons, but the work of the justices oftentimes is trying to sort of flip things around, thinking about what is the broader principle at play here. I'm just gonna say, honestly, in this case, the broader principles really do cut both ways in difficult circumstances. It's just difficult to sort of have a clear cut up or down on this particular case. So with that, I think we're gonna have some discussion and questions.
I do want to make note that there's an error on the slide. And if you'll notice that Chris is from Chicago Kent Law School. Even though Steve paid extra to have him be at U of I, he is not. He's at Chicago Kent.
We're gonna get Chris to come.
This is great. I got the job.
It's a little recruitment ploy, but it's not going to work.
I don't know how to read this to the Q&A slide. Ironic, huh? Okay, the first question is, if the Florida and Texas bills say you can't regulate content, Does that mean they have to let stand a post that gives the wrong time and polling place for an election?
That's a fantastic question.
I wish I asked it.
You know, we were talking before the session today, and I so appreciate the many opportunities I've had over the years to talk to League of Women Voter groups, because I always get probing and trenchant questions that kind of cut through all the crap and just ask, what are we talking about here? And this is one of those. So, it really, I've said it before, I'll say it again. It's a real true honor to be with you today. And I so enjoy these discussions. Yeah, quite possibly. Those kinds of things are, among other things, what are potentially at issue here. We know that there's a lot of disinformation out there around elections, places of elections, how to vote, whether you can collect ballots for other people, where to drop them off, when to drop them off, whether you need to sign the outer envelope and date it or just the inner one. Yeah. And those statements about that could be considered content, maybe even viewpoint restrictions on speech if the social media companies are clamping down on that kind of speech. And so, yes, that is potentially in play. And, as Chris just said, such a good point, such a healthy reminder that when you think about First Amendment doctrines, you really need to think about both sides, right? And so we're talking about what predominantly is politically conservative speech that seems to be promoting disinformation and outright falsities and lies on social media. But we can imagine a world where progressive speech was falling into those categories, right? And the rule that we come up with, whatever it is in these cases, really has to accommodate both potentialities so that we can all be happy with it in the end. But yeah, that was a fantastic question.
I'm just going to pick up on that a little bit more because I was fascinated that question arose as I was prepping this material, and I did do a little digging around. And in fact, there has been legislative efforts to deal with that specific problem. So in Congress, there was a law proposed. It didn't get through, I think back in 2021, designed to sort of protect the integrity of elections, in which they would actually make it, I'm not sure if it's criminal or civil liability, but basically it'd be against the law to have factual misinformation that was aimed to try and prevent someone from accessing the vote. And the principle at play here is election interference. And some states actually have some laws that they're trying to push through. And then there's just some question about, might there be First Amendment concerns? And I think most people who look at this say that if you're straight up prohibiting factual information that is designed to take away someone's vote, that's election interference, and that does not run afoul of the First Amendment. I will say, then you take the half step further and say, well, what about people who are saying we can't trust the election because there's something shady going on there? That's where it gets tricky, because some of the state legislation did seem to capture this as well, which is not super far afield from something that would disincentivize someone from actually going to the polls, right? But that does also seem to be expressing a particular position that could have a political meaning that's not as clear cut as polling ends at 2 when in fact it ends at 6 or something along those lines. So I do think just the straight up factual information as disinformation probably could be directly regulated, but that does get you very close to those harder questions that the courts are going to be struggling with.
Great. Thank you. The next question is, why aren't social media platforms regulated like radio and television? Is it the lack of political will that has prevented this type of regulation? Is it too late to impose this type of regulation?
So I'll take a quick stab, and then Steve, feel free to jump in. Part of it is technology, right? New technology sometimes gets shoehorned into old boxes and sometimes sort of forges on its own. And the internet kind of has broken away from radio and cable television, and that radio and cable television are more thoroughly regulated than the internet. Now, the basic principle underlying some of this, other than just inability to adapt to new circumstances, is that there is much more resource scarcity when it comes to things like cable television and radio, and that government gives licenses to individuals to provide this resource, and therefore there's a level of scarcity. And when government creates scarcity, then it has some responsibility to oversee what's happening, and therefore government does exercise more limitations on content in, say, television and radio. Whereas in the internet, scarcity is much less relevant. It's not like you get a government license to start a blog. You can just go out there and do it. And then this gets back to the idea that the government is not imposing scarcity. It's a bit more of a free-for-all. Therefore, government has more limitations on what it can do. And then the principle that Steve nicely highlighted at the beginning, the marketplace of ideas, to throw more speech is the proper remedy. That may not fit so well in the world of radio and television. It does arguably fit better in the internet context. That's the current situation, but also there's a lot of people questioning whether government should in fact do more, whether government should treat internet more like the common carrier utility idea that Steve talked about. But that's currently something that the courts are struggling with.
Yeah, just in terms of free speech, leaving the common carrier question off the table, you know, more and more traditional media has become more and more open. And so the scarcity issue that Chris described, you know, animates the court's jurisprudence, but it might be a little antiquated here because we're seeing, for example, you know, I don't know about you, but I read my New York Times online these days. And the content that I get, you know, certainly matches mostly the print edition, but it's sequenced differently, it's presented differently, it's a very different format, and allows for an interactive element that the print edition doesn't. For example, what's kind of interesting about the cases that I described is that, you know, some of the parties, many of the parties are arguing that this is exactly the question that we ought to address. How do social media platforms fit within the framework that the Supreme Court has devised that Chris described, where we have some media that are more restricted than other media? I mean, in some ways, I just think that's a wrong question because we're just in a new media landscape entirely. That said, I don't really have any idea what the Supreme Court's going to do here. We have a couple of recent data points from the Supreme Court where it ruled on free speech on the internet in the context of congressional attempts to restrict access to what Congress said was inappropriate speech for youth. And the approach that the Supreme Court has taken in those cases is a kind of, you know, Wild West marketplace of ideas on the internet, anything goes kind of idea. And so, you know, to the extent that the court seems leaning in that direction in this other context, I think it may be leaning in that direction with social media as well.
Thanks. Can the speakers clarify the distinction between misinformation and disinformation? Whether the courts view them differently in terms of free speech protection?
The second part is what I got stuck. I mean, so the basic distinction, as I understand it, is misinformation is misleading or false information that's out there without any statement about the intent behind the people putting that information out there. So someone seeing something that may be factually wrong, retweeting it because they like what it says, versus the disinformation, there's intent behind it. There's intent to deceive in the promotion and promulgation of particular information. In terms of whether there could be First Amendment difference based upon the intent, my gut instinct on that is no, it doesn't seem to be meaningfully different from a constitutional perspective, but I'd have to think on that. And again, these are terms that the court, these are relatively new terms in common currency. I mean, I think just a few years back is where they really became big. So they'll definitely feature in these cases the courts are looking at. Whether they see any difference in how they deal with it, my thought is probably not.
Okay. I agree. I don't really have anything to add. I agree.
You stumped the panel.
Okay, the next question is, what impact does harming people, for example, a politician telling people to attack a private citizen, have on these cases? What role does government, sorry, it's abbreviated, does government have in protecting people?
It's a fantastic question, and it's, it may or may not be the thrust of the question, but I'm gonna inject this additional thought. These cases come to us in the context of COVID mis and disinformation and election mis and disinformation. And so on that level, we obviously can't ignore the political context. But there is something else going on here, and not to be too political about it, but former President Trump, right? And Trump's actions that have been truly extraordinary in so many different ways are extraordinary in these ways as well. And so to what degree can the government protect us, or should the government protect us consistent with First Amendment principles against a candidate for office, or even a president who is actively threatening people, right? I think that's an important question. Threatening speech could potentially fall into one of those categories that Chris and I both talked about of unprotected speech, for example, incitement or fighting words, and therefore be unprotected speech. And what that would mean is that the government could punish the speech. And so there is that possibility that's not raised in these cases, but that kind of thing is, I think it's impossible for that not to be operating in the background here. The other thing, there are a couple of social media cases that Chris and I didn't talk about that are on the court's docket this term about public officials, and these are local public officials who had social media accounts that sort of blurred the line between official accounts and private accounts, right? They ended up blocking people from their social media accounts, and then those people sued, saying that the individuals, the public officials, were violating their First Amendment rights by blocking them from their accounts. Now, this should sound familiar to you. We had a case about former President Trump doing exactly that, right? And so again, yet another instance of this sort of shadow of Trump, this giant shadow of Trump looming over all of these issues in important ways that I think are impossible to ignore. But these particular cases and the way the court will deal with them and their particularities, I think will probably ignore that larger looming over, and will probably say nothing about whether and how the government can protect us, for example, from threatening politician speech.
Okay. Is there a way to legally require that all news providers, that's news in quotes, are transparent in who they are and when they are providing commentary instead of news? Something like the disclosures in a prescription drug ad, for example. And then this is, why can Fox News call itself news when it has argued in court that it is news entertainment?
So I do think there is some opportunity there working within the constraints of the First Amendment for this kind of regulation of media providers. I mean, just to sort of distill that down to maybe simplest example, could government require news providers to clearly distinguish between opinion and reporting? I think the answer there would be yes, because it is a commercial regulation and it has to do with false advertising, right? Which is classic government speech regulation, which is permissible under the First Amendment. And the goal there is not to get at the content nor the viewpoint of the speech. The goal is actually to give the consumers an accurate understanding about what they are paying for, what they are receiving. And again, like false advertising and say drugs or something like that. I think that kind of regulation probably could do okay under a First Amendment challenge if it's framed in a relatively narrow way. Of course, I'm going to say that, I'm going to lay that out there. And then, of course, the line between commentary and reporting, even in the, I'm a historian, like there used to be like no line. If you go back like 100 years, that line actually developed like in the mid 20th century, where there's a clear distinction between opinion and reporting, and newspapers really valued that. And then that line is broken down again, which is to say that there's actually a lot of gray area between the two. But as a start, sort of if you have something that's clearly opinion versus something clearly more factual or claims to be factual reporting, to have a requirement, that seems to be actually okay under the First Amendment, I think.
Yeah, I agree. The trick would be figuring out when you cross that line. But, I think this is another point where it's important to remember that the rule that we devise for First Amendment free speech has to apply both ways. And so I was a little taken aback today, for example, as I was getting ready to come here, I had MSNBC on in the background, guilty as charged. And the interviewer was interviewing a politician. I don't even remember who it was or what it was about. But the interview stopped, and then the interviewer went on to editorialize for like 15 seconds, shut the politician down, and end the segment. And I'm like, what just happened, right? And so it's got to operate both ways.
We know that China, Russia, and other bad actors utilize our US social media platforms to spread mis and disinformation to influence US elections. What should the platforms do to prevent these actions? In other words, because it's a foreign entity, is there any different?
So I think there the answer is yes, because you have both election interference as well as national security issues. And those are both two categories which I think get lower levels of First Amendment scrutiny, particularly in the area of national security. So there's speech threatening national security. And I think the integrity of our election system would clearly fall under that. Then government regulation of that form of speech would likely be permissible or would have a very low level of First Amendment scrutiny that could be justified. And as I said before, I think straight up protecting election integrity, access to polls probably also could be regulated. Speech could be regulated in that space and not run afoul of the First Amendment.
The issue that what I find so interesting about this is that it's becoming more and more difficult to figure out who's saying what, right? And so if there are foreign powers against that are promoting speech on social media, they oftentimes are sophisticated enough to do it in a way that it's really difficult to know that it's them that is doing it, right? And I guess I'm reminded too of the robocall recently from President Biden. Did you hear about this? Mm-hmm. Yeah, the AI robocall that Biden put out, basically telling people not to vote. Truly, truly extraordinary. And so as AI ramps up and we get more sophisticated with our ability to speak but hide who is the speaker, I worry that however we attempt to regulate it in perfectly valid ways, I totally agree with Chris, but however we regulate it is not going to perfectly capture the problem, just because we're always going to be trying to play catch up with technology.
Whatever happened to the fairness doctrine gone in 1987 that forced news networks to present two sides of each issue?
Well, that kind of went away. Under First Amendment free speech principles, the government can't compel a news outlet like a newspaper, for example. There's a famous case on this, to present both sides, and that's part of what that doctrine is working its way into these cases, because we are talking about, in some ways, compelling third-party speech of the platforms, or restricting their speech based on this sort of fairness idea, right? Looming in the background is the Miami Herald case that says you can't force a newspaper, for example, to present both sides of an issue.
Okay, we're going to do one more, and this is not to do with social media. How does school book banning fit into the free speech realm? We only have another 5 minutes, just so you know.
Do we have another panel?
Exactly.
I mean, the one thing to keep in mind, at least the first run through, is that government control over what goes into libraries, what kids read, is very speech repressive, but it's completely acceptable and it doesn't violate the First Amendment. I mean, curriculum decisions, what goes into a library and doesn't go into a library, generally doesn't raise First Amendment issues because this is just an area of society in which historically government has always made decisions and decisions have to be made. And therefore there need to be some limitations on that. Having said that, some of the political efforts to ban books do seem to raise some of these First Amendment issues. As a general matter, I would fall back on my distinction between First Amendment principles and culture versus First Amendment law. There's not a lot of First Amendment law that they run afoul of because of the long history of government control over speech within the schooling and educational context. But if you want to fight against them, you do raise First Amendment principles because you have, this is a basic principle that even if you can't go to court and win it, this is how arguments take place. And we do have in this country, we have constitutional law, which is what courts tell us the Constitution means. We also have constitutional culture, which is what we as a society talk about, how we fight about things. And that also should be informed by our basic constitutional principles. So, as a law professor, I'd say that's not a likely First Amendment issue, but as a citizen, I think it actually is a free speech issue, of course, and we should talk about it in those terms.
Yeah, that's a really good point. I'm going to just kind of pick up on that and carry it forward. What we're seeing in some of these book banning cases is deeply worrying to me, both as a matter of free speech principles, but also as the way we interact as democratic citizens in a democratic society, right? And so to the extent that school boards or local authorities are taking books off the shelf because of their content or viewpoint, that, for example, promote things like equality, right? This really is setting citizen against citizen in ways that I think is just unhealthy for a democracy. But what I really worry about is those districts and those states that allow individual parents, independent of the school district, to select and identify books that they want to target for taking off the shelf. This is so reminiscent to me of what we saw in Texas with the abortion debates pre-Dobbs, where if you remember, the Texas legislature passed a law that allowed citizens to sue citizens who were engaged in abortion, right? And what we see, in my view, is just this kind of trend of promoting public policies in a way that divides us as citizens. And I think that's so destructive of the way we interact as democratic citizens in a democracy. And so the free speech issues, I think, are hugely important here, but they are principles. They're not law. School boards have a lot of control over the content that they put on their library shelves and that they promote in the classroom. But what we're seeing is deeply worrying to me in terms of the health of our democracy.
And on that happy note, thank you. We actually didn't introduce ourselves. My name is Ann Sullivan, and I'm with the League of Women Voters of Wilmette, and I'm with Barb Lymans, who is with the League of Women Voters of Wheaton, and we are the co-chairs of the newly formed League of Women Voters of Illinois Mis and Disinformation Task Force. Thank you. I hope we deserve applause. So we just briefly wanted to cover what the task force is doing and invite all of our local leagues who are here to be part of what we're doing. Our mission is, the primary purpose of the task force is to strategize and implement measures that educate and counter the spread and impact of misinformation and disinformation across platforms. Our tactics will focus on specific actions, not just awareness. And specifically, we're going to be covering public awareness and education, collaborating with established organizations who have developed best practices to fight disinformation, and providing public seminars and workshops. We have many members, I think, of our task force that are here in the audience. Do you guys want to wave if you're part of the Mis and Disinformation Task Force? We started meeting in November, and we're really kind of a work in progress. But what we hope to do through our education, voting and elections, communications, and response and reporting subcommittees is to really put together not a curriculum, but several different education modules that you can use in your local community to help fight disinformation. So the power of the League of Women Voters is not just that we're all here together as, you know, citizens of the state of Illinois, but that we are really the boots on the ground in our local communities. And we are a trusted source of information for citizens, especially surrounding elections. And so we want to, on the state level, put together educational materials and also communications, letters to the editor, newsletter articles, things that you can use that are very practical for fighting disinformation in your community. We also need your help in finding out what kind of disinformation is out there. So we've established a response and reporting mechanism. I'm kind of skipping around on my bullet points, sorry. But we're going to have a form on the website where you or a citizen, you know, it doesn't have to be a league member, anybody can come and report disinformation or misinformation that they're seeing. And we've already, just in our few months of operation, had a couple of reports of bad actors going to a county commission meeting, you know, and spreading disinformation. And so it will help you to anticipate tactics that are organized on a broader level that may be coming to your community soon. So when you see mis and disinformation, when you see what was referred to earlier as the pink slime in your grocery store, you know, you can report that to us and we will analyze the reports that we get. And if it's appropriate, we will recommend action that you can take. We do have 2 events already scheduled, educational events that are open to all league members and members of the general public. Oh, wait, go back. Right now, our website is not, our webpage is not fully developed. We were hoping to have it for today, but there are a lot of priorities. So in the next couple of weeks, we will have a basic website, and that's the QR code for it. That'll have a lot of this information on there. And we also have an email address, which is missdisinfotaskforce@lwvil.org. And you're welcome to email us with any questions, or if you would like to help out as a point person for your local league. And we passed out some information at the table that has a little bit of information about the, I don't want to say job description, because this is really something that would only take, I don't know, an hour or 2 a month at the most, that you can be the person that facilitates our educational materials getting out to your local league board, your communications person, you know, just so that the president of your league doesn't have to necessarily do that. So it's a great opportunity for a volunteer that you're trying to cultivate to get involved in a topic that is, I think, very important to all of us, and a very interesting topic and a very important topic to our democracy. They could also be your local point person. So here's the 2 events that we have scheduled, and this QR code, because I love QR codes, obviously, is the registration link for the first one, which is on March 6th at 7 p.m. It's via Zoom, and it's how Illinois strives to ensure a secure election process with Matt Dietrich, who is the Public Information Officer for the Illinois State Board of Elections. And this is in advance of the March 19th primary. Just because you may get questions about whether the election is secure. You may get questions about what's happening with mail-in ballots. You may get questions about whether people can vote twice. We know the answers to these questions, but we can also point back to what Matt has to say and what our local election authorities has to say as a trusted source of information, because that's the best way to fight disinformation. You know, it would be great if there it's going to be a long time before there is any regulation of social media, or maybe there won't be, I don't know, but you know, we can take action by pointing people to the right sources. So that's what the idea of this is. And then on April 17th, talking a lot about social media and AI today, we have Diane Chang, who is entrepreneur in residence at the Institute for Media Innovation at Columbia Journalism School, and the former head of election security or election integrity product strategy for Meta. So she worked for Facebook during the last election, and she has a lot to tell us about how we can protect democracy in the age of social media and AI. We don't have the registration link for that one yet, but we will put it in the newsletter, and we will send it out to our liaisons in the local leagues, because I know we're going to have a lot of people that want to sign up to do that today. Anything else, Barb?
No, we just welcome your input. We welcome if you could spare a little time for us. This is a huge task for our democracy to make sure everyone feels comfortable in going to the polls and making a choice based on sound information in November. So please contact either Ann or I. And once again, thanks for listening. We'll thank you in advance for your participation. And we're going to let you take a 5-minute break before our next session.